Welcome to the last in our series of Rural Dispute Coffee Break webinars. For those of you who haven't tuned in before, my name is Elaine Brailsford and I'm joined yet again by Stephanie Hepburn.
Hi there.
Today we are focusing on occupiers' liability in the countryside and in particular the duties and obligations owed to open water swimmers. It seems from the news reports that more people than ever are participating in open water swimming, with a surge of interest during lockdown. And in England, we hear of local communities being overwhelmed by people heading for open water. Also in Scotland, open water or wild swimming in seas, rivers, lochs is also on the increase. But before we look at open water swimming particularly, we're going to look at occupiers' liability in the rural sector generally.
So, occupiers' liability is governed by the Occupiers' Liability Scotland Act 1960. The general thrust of the Act is that occupiers of land owe duties of care towards those that come onto the land. And that duty is to do what's reasonable so those don't suffer injury or damage. And it applies to both positive acts and also to omissions. And obviously, what's reasonable will depend on the circumstances of the case. The onus lies on the injured party to show the occupier didn't take reasonable care. So who is the occupier then? Well, the occupier is the person who has control of the land. Usually that's the landowner, but occupiers' liability may extend to third parties like tenants and contractors if they're in control of the land.
So in the countryside, estates and farms can be dangerous places, particularly to the unsuspecting visitor. And of course, the right to roam is usually exercisable over these areas. Occupiers of land that pose a greater than usual risk to third parties need to take extra care. In 2017, a case was brought by Craig Anderson against Mr and Mrs Emery, and this case reinforces this. In June 2003, Craig Anderson, then only 8 years old, was being looked after by Mrs Emery at the family farm, where she and her family lived. Mrs Emery had allowed her young son and young Craig to play in the courtyard outside the front of their house, but she had warned them not to venture further out of sight and not to go into the working areas of the farm because these were dangerous. When Mrs Emery was away for a few minutes, the boys, needless to say, ran out of her sight in a bid to try and round up the farm sheep.
Just see that could happen, can you?
Yeah, mother of 3 sons, I definitely can. When trying to open the stable door to herd the sheep in, Craig climbed onto a heavy gate covering the doorway, which was only secured by a chain or a rope. And the gate came free and fell on top of him, and it caused him injuries to his skull and brain. It was argued that Mrs Emery had not been watching the boys and that they were mainly left to do their own thing. The accident had caused Craig long-term damage and had also affected his employment prospects. So years later, in fact, he sued for damages, and Mrs Emery was found to have breached her duty of care towards Craig. Now, both Mr and Mrs Emery were sued on the basis of a breach of duty incumbent on them as occupiers of the farm in terms of Section 2, subsection 1 of the 1960 Act. And separately, Mrs Emery was sued under the common law in what was referred to in the case as the childcare case. She was effectively in loco parentis. In considering liability, the judge at first instance distinguished between the respective positions of Mr and Mrs Emery. Mr Emery had nothing to do with the arrangements for Craig to come to the farm. He had no reason to suspect that Craig might climb over the gate and detach the stock gate. He had no reason to suppose it would topple over. So he was found not to be in breach of the duty owed as an occupier of the farm. Different factors came into play with Mrs Emery. She was, as I've said, in loco parentis. She was aware that the farm was a dangerous place for children. She should have foreseen that the boy could get injured if he interfered in some way with the stock gate. The Lord Ordinary found that it was a foreseeable danger that if not adequately supervised, Craig would suffer an injury on the farm. So Mrs Emery was found to have failed her duty under both the Act and at common law. She appealed, and she argued that the Lord Ordinary had applied too high a standard of care. But she failed in her appeal. It was conceded that the case brought under the Occupiers Liability Act did not add anything to the common law case based on the liability of those in charge of children. The decision at first instance was upheld. On the facts of that case, it was said there was a range of hazards on the farm which required a high level of supervision. Mrs Emery was in breach of both the 1960 Act and at common law, and she was ordered to pay £325,976 in compensation. And I don't actually think they were insured. Is that right, Steph?
Yeah, there was problems with their insurance. It's an interesting case, that one. I think it highlights how important it is in the rural sector to take steps to keep property or land sort of secured and maintained in a good standard of repair. And of course, as you said, having the good occupiers liability insurance in place in case something does go wrong. We've got an article on this case that I've put in the webinar resources section, and that's got a non-exhaustive list of recommended precautions that might avoid occupiers liability. Things like putting up warnings, protection signs, bearing in mind more warning might be required if young children are allowed to cross the property. So I think also one important thing to bear in mind is always carry out risk assessments, checking the condition of fences and gates and access to any outbuildings, ensuring that, if possible, gates are secured in a way that can't be opened by animals or children. I think where kids are concerned, you can't be too safe. I've got a 3-year-old. I know how unpredictable he can be and how fast he can be off exploring a riverside or a bridge. And we all know that children don't like to listen to warnings. Well, my son certainly doesn't. So if there is a likelihood that children might be on your property, I think it's important to consider all eventualities, even ones that might not seem required for adults. Other cases that have been reported in this area in this rural sector include liability arising from a sunken gully beside a cycle path, falls into a ha-ha, uneven paths, dilapidated outbuildings, and even poisoned berries. There was a case about that.
Oh, poisoned berries. I'm really keen on identifying wildflowers. I'm digressing here. I'm really keen when identifying wildflowers when I'm out walking. And I have a brilliant app on my phone that takes a picture of the flower and tells you all about it. Its Latin name, etc. So you won't catch me out with.
Well, this case was back in 1952, so no Google Lens or anything like that back then. So, yeah, it was a case of Taylor against Glasgow Corporation, where a child died as a result of eating poison berries growing in Glasgow Botanic Gardens. The shrub where the berries were growing wasn't fenced off, and there wasn't any warning signs present. Children were obviously often at the botanics, and I can see how any kind of berry would be quite alluring to children. Obviously, like I said, it was back in 1952, so health and safety has moved on since then, but it's quite a good example of extra precautions that should be taken when kids are coming onto the land. Although I think, like you, Elaine, I might need the warning as well, because who can't resist berries in the countryside? Although I might now check with Google Lens or a similar app first.
In the countryside, there may be risks where it's impossible to guard by putting in place protective measures. For example, in Graham against East of Scotland Water, the court held that the occupier of a reservoir, which was separated from a main road by a wall, as low at some points as 30 centimetres, which I think is about a foot, easily low enough for somebody to jump off or to trip over, but the occupier did not have a duty to fence it off. And this was because the reservoir and the wall were well established, permanent and familiar features, so said the judge, of the landscape, even though they were man-made. Now, the same may apply to a path by a river. There's always the danger of someone falling in, but that doesn't mean it's always necessary to fence the river to prevent children or careless people falling in. Although, I mean, it may be prudent to do so. It all depends on the circumstances.
Your favourite saying, Elaine.
Facts and circumstances. I mean, we're not suggesting that you go out and put a fence around Loch Ness, for instance.
So looking briefly now at who this duty is owed to, Elaine mentioned those exercising the right to roam, and the duty of care extends to those. So those access takers are treated in exactly the same way as someone who's actually invited onto the land.
And what about trespassers then?
Yeah, so unlike in England, the 1960 Act doesn't make any distinction between a class of visitor, so occupiers owe duty to anyone who enters, whether they're a trespasser or not. But I think who they are and how they came to be on the land is going to be relevant in assessing any level of duty that's owed to this person.
And is the duty to protect against all risks?
No, so an occupier is not expected to take proactive steps about every possible risk. There have been cases where the courts have found there to be no liability in circumstances where an occupier failed to erect a fence between a bench and a cliff top, for not providing a handrail at a turn of a man-made path on a hill. Mm-hmm. And we'll come on to that a bit more detail when we'll look at open water swimming in a moment. But I mentioned falls into a ha-ha earlier. You might be aware of the case of Cowan against Hopetoun House, where Mr Cowan tripped and fell into a ditch within the grounds of Hopetoun House whilst taking his grandson on a guided bat walk at night, and was awarded about £8,500 in damages. And Lord Brackadale said that a ha-ha should be distinguished from a natural feature like a riverbank or a cliff, and said that a ha-ha is an unusual feature of a concealed nature, particularly in the dark.
Ha-ha. But what was
it in the script, Elaine?
Well, what was Mr Cowan doing at night with a grandson in the grounds of a castle? I mean, really, I hope he was found contributory negligent.
Yeah, no, he was in that case. So, moving on, Elaine, to open water swimming.
Well, while in open water swimming, the occupier's liability provisions will apply to those invited onto the land to swim. So in organised events or triathlons, that's a different class of people to those just deciding to take a swim in a loch uninvited. So presumably, Stephanie, you're the expert on right to roam. You can exercise your right to roam by swimming.
You can, yes. And this will also extend to open water swimming.
Are there any circumstances where the right to roam does not extend to swimming? For example, if there's local bylaws which prevent swimming.
Yep.
Also, I think the right to roam cannot be exercised if there's been developed or set, the land's been developed or set out as a sports or playing field. Mm-hmm. And that is an exception to the right to roam, as is land used for a particular recreational purpose. We gave advice in a case where a loch on a client's land was developed as a recreational water sports activity centre. And thus we were able to argue that members of the public who were coming on, out of hours, so to speak, swimming in the loch, were not entitled to do so because the public access rights did not extend to the loch in those particular circumstances. Perhaps more niche is the right to roam does not extend to land where, for not fewer than 90 days in the year ending on the 31st of January 2001, and not fewer than 90 days in each year ever since then, members of the public have paid for admission.
Yeah, that's right. So looking now at an occupier's potential liability for any injuries or loss or damage sustained by an open water swimmer, whether invited or exercising the right to roam, the duty of care in the 1960 Act may extend to open water or wild swimmers, but an occupier isn't normally expected to guard against dangers that are obvious or that are inherent in the ordinary and familiar features of the landscape, whether that's natural or man-made. The English case of Tomlinson against Congleton, I think it is an interesting one about open water swimming particularly. And in that case, it was a lake in a country park. you weren't allowed to swim in the lake, and there was clear signs up that said this, and the park rangers were asked to prevent swimming. A young man broke his neck when he dived into the lake, and the House of Lords didn't find the landowner liable, reaffirming the principle that there wasn't a duty to warn or take steps to prevent the claimant from diving, as the danger was perfectly obvious.
But what is obvious in the situation of open water swimming? I mean, can someone tell whether a body of water is an obvious risk? Surely if swimming was permitted, the landlord does have an obligation to put up signs saying danger, rocks or whatever.
I think that's right. I think swimming is one of those things where, like say, I don't know, a cliff face or something like that, the risk might not be obvious. It might depend whether it's obvious there are rocks or a strong current or something like that. When you mentioned the East of Scotland water case earlier, in that case it was impossible to guard against the risk by putting up a barrier or a fence, so that might be a relevant factor as well. We do see this in every webinar, and Elaine mentioned it earlier, but it does depend on the facts and circumstances in every case. And I mentioned that risk assessments are absolutely crucial, and so is seeking appropriate advice at the relevant stage.
The 1960 Act explicitly excludes any obligation of an occupier over risks willingly accepted by the visitor. That's section 2, subsection 3. And this could apply to risks that may be inherent in any pursuit such as swimming, and certainly more risky activities like rock climbing, where, depending on the circumstances, the access taker may be taken to have accepted the risk of injury if they have an accident. It's pretty risky to walk along the edge of a sheer cliff. The grey area comes, I suppose, where it may not be obvious that the cliff has a steep drop. And that's where fencing off or signs may well be required.
I think what we're saying is, whilst an individual may be allowed to engage in open water swimming or some other activity at their own risk and also enjoy the pleasures of the countryside, and also occupiers might not want to incur expense in putting up barriers or fences or whatever, but the prudent course of action is to act responsibly, and no matter what the risk is, ensure there are clear and understandable signage, and if required, barriers are put in place. I mentioned earlier some precautions, like risk assessments and locking gates and things like that as well. The Outdoor Access Code suggests that responsible behaviour by land managers includes indicating where people can best take access to a river or a loch, and that might help minimise any problems. I think, though, I can see a bit of tension between all these steps to put protections in and prevent the access to safeguard against injury and prevent liability occurring to those that are in control of the land, vis-a-vis the obligation not to prevent the right to roam being exercised. I can see a lot of a tension there, because on the one hand, landowners have to not prevent the right to roam being exercised by putting up fences, yet they need to make sure that they're not exposing themselves to liability for injuries.
Yeah, I can see there is a tension there. That's possibly a webinar for another day.
Maybe, we'll see.
Well, that concludes our summer series of lockdown coffee break webinars.
Oh, yeah.
Thank you all very much for listening to them. I think that the link to them is still available, so anybody that's missed any or wants to rerun them is free to do so. Stephanie and I will now sit down and work out what other topics might be appropriate for the next series.
Please let us know if you have any ideas or even anything we can expand on. 15 minutes isn't a long time to cover much of these topics, so we can certainly expand on some of them in more detail if that would assist.
So please do get in touch with us. And if you don't, I'm sure we'll be getting in touch with you. So once again, thank you very much for your attendance. Bye.
Bye.